Let's move on to this now. A suspect in the ZanZou nightclub abuse case appeared before Pretoria Magistrate's court on Monday, where he made a formal bail application. Now, the 41-year-old Congolese national was a bouncer at the club and was arrested following the circulation of videos of the shocking abuse of patrons. Now, the state said it would oppose bail as the man is a flight risk, despite him saying he's in fact an asylum seeker. In addition, an 8th victim of the assaults has come forward. The suspect's bail hearing continues next week. Let's discuss these developments and the prospects then of this case now with legal analyst Mpumelelo Zikalala, who joins us now. Mpumelelo, thank you so much for the time. Let's just get a clear sense of what you make then of proceedings thus far as we have them, particularly, of course, as the bail hearing was then had as well earlier this week.
Good morning to you and also good morning to our viewers. I think it's just a normal proceedings that will take place, but we must remember that it's highly guided by Section 60 of the Criminal Procedure Act. There are a number of things, a number of questions that will be asked there, the very first one being, what sort of family ties do you have in South Africa? Do you have any family that is here? What are the chances of you that you are going to have a child? Now, if you don't have a fixed address, there's nothing that binds you to South African roots. So if you go to another country, you can easily function. Then the chances of you being able to get bail are going to be very slim. So it seems as if that's the process which is being engaged in. But you must also remember that the merits of the matter or the main trial has not been touched, probably because still further investigations which are taking place. However, the courts will listen to the bail application and ask that bail application according to what the law is saying, in particular, the Criminal Procedure Act.
So the fact that he claims that he's an asylum seeker, if indeed is an asylum seeker then, would that account for anything, or would that count for anything with regards to this bail hearing?
In fact, in my view, I think it would count against him, because if you then say that our courts have stated in previous cases that if you have a house, if you have a family, if you're running a business, if you're employed, then the chances of you remaining in the country and wanting to protect that particular family structure are quite high. If you don't have any of those and you're simply, for lack of a better word, a visitor in South Africa, if you move to another country and be an asylum seeker there, you'll be able to survive. Then there's nothing holding you to South African roots, and there's no allegiance to any of the South African process that you might have. So the chances of you being able to evade trial and be able to go are quite slim. Another view would be, if you're able to come to South Africa without any papers, without following the proper procedures, you're only recognized once you are inside as an asylum seeker, what's stopping you from going to Zimbabwe, for example, or even going further north up until you get to Egypt? And by the time, then the question would be, what processes are going to be there employed by the SAPS? They can be able to track you down. Or what assurance are you going to give us that you are going to come back if you issue and bail? Those are the very pertinent questions which are asked by the presiding officer hearing your bail application. And it's up to you as the applicant, in this case, the accused, to try and persuade the court to say, I have all these elements which are in my favor. Please trust me that if you release me on bail, I'm going to come back and attend my trial until it gets to the end.
Yeah, an interesting one here when it comes particularly to that asylum-seeking prospect as well. Let's get to the state's case here when it comes to the strategy of understanding that there may even be more suspects here that come to the fore as the days and the weeks and months really move forward here on this one. We now have an 8th victim who has come forward. What's the strategy that perhaps could be laid forward here from the state?
I think the state would want to say, we want to try and hold on to everyone that you've been able to arrest. We do not want to release anyone while you're still trying to get to the bottom of this investigation. Remember that everything happens so fast. It is not a type of crime in which maybe the state would have had ample amount of time to go and investigate before people are arrested. So the manner of arrest and how it was done, it is due to a video that comes out. We need to act as quickly as possible. We identify the individuals and we arrest them, but the process of investigating is still there. Investigating with the process of saying, we now understand that when we go to court, you have to prove beyond reasonable doubt that these are the individuals that are there. So the placing of the individuals on the crime scene, the extent in which those particular sort of violent acts took place. Are there any JADAs or doctors that were visited? We need to go and collect all of those. Are those doctors even alive? Are other victims even alive? Is there cell phone evidence that can be utilized in bringing all of those in? Is there any other person that can be able to collaborate what the victims are saying? So that's the type of evidence which is required. And it is only then when that evidence has been collected, in which then the state will say, we are now ready to go to court, we are now ready to deal with the matter at trial, which is why I anticipate that it may happen that before the trial, we actually get to trial in this matter, there's going to be a few postponements which are going to there, while the state is still trying to gather evidence and making sure that when they go to the other side on trial, they come back victorious.
Just as a final question then, Mpumelelo, yes, the accused is a 41-year-old Congolese asylum seeker in this regard, but the role then of the owners of ZanZou itself then, particularly in understanding what was going on prior and during all of this, as well as then now in this court case as well. How much do you think they have to account for pretty much? And does it mean that they will need to play a very key role when it comes to the court case?
They need to. They are part and parcel. If it wasn't for the establishment, for sure this particular crime would not have taken place or allegedly have taken place. So they need to come and say, when it comes to employing individuals, are there any charges that can be laid upon them? Remember that the individuals are not acting out of their own personal capacity. They are acting under the instructions of the entity. So they need to confirm, is it a policy that when someone doesn't pay their bill, this is the man which are going to punish them? And if it is, they may find themselves, or the owners or the managers, being accomplices or being branded under what we call the doctrine of common purpose, where despite them not being actually involved in the assault, but due to their instructions and the criminal mind in which they had, they may be punished just as same. So they are not out of the woods as yet. They are part and part of the investigation, and they need to make sure that they're able to explain to the police what their role was. But in explaining that, be able to exonerate themselves to say, it is not our policy, we have not taught our employees to do that. It's simply that they took this particular process on their own, and you can't be held liable for that.